This is a case that's been bounced around back and forth throughout the court system.
All right, we've got this breaking news just coming into our newsroom right now. The Supreme Court has issued a ruling.
The Ninth Circuit upheld California's ban on magazines that hold more than 10 rounds.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
There's a document circulating through courtrooms right now that has politicians in absolute panic. It's not legislation. It's not a presidential order. It's a court ruling that just demolished decades of gun control strategy in one devastating blow. And here's what makes it terrifying for certain lawmakers. This isn't happening in Texas or Wyoming. This happened in the Ninth Circuit, historically the most anti-gun court in America. The same court that rubber-stamped every restriction, every ban, every limitation for years just reversed course entirely. What they ruled is so significant that it could unravel gun control laws in over a dozen states simultaneously. Magazine bans that took decades to pass, gone. Restrictions that were considered untouchable, suddenly vulnerable. And the legal reasoning behind this decision creates a domino effect that threatens to collapse the entire framework of modern gun legislation. Politicians promised these laws would make people safer. Courts just ruled they were never constitutional in the first place. What happened in Duncan versus Bonta isn't just another legal victory, it's a constitutional earthquake. And the aftershocks are about to hit every state in America. For years, California led the charge on magazine restrictions. In 2000, lawmakers banned the sale and importation of magazines holding more than 10 rounds. At first, possession remained legal, people could keep what they owned. Then 2016 arrived, and the rules changed dramatically. Possession itself became criminal. Millions of law-abiding citizens faced an impossible choice: surrender legally purchased property, destroy it, or risk prosecution. The justification was always the same: public safety. But here's what the narrative ignored. These weren't exotic military accessories. Standard capacity magazines are factory default for America's most common firearms. A Glock 17 comes with 17 rounds. An AR-15 typically holds 30. Most modern pistols range between 12 and 19 rounds. Calling them high capacity was linguistic manipulation designed to make normal equipment sound dangerous. The reality? What California banned was simply standard. The week that changed everything. Then came 2019, and something unprecedented happened. Federal Judge Roger Benitez examined California's magazine ban under constitutional scrutiny and delivered a ruling that sent shockwaves through the state. The ban was unconstitutional, period. His opinion didn't mince words. Restricting magazines in common use violated the Second Amendment. The immediate result became known as Freedom Week. For one brief window, Californians could legally purchase, sell, and import standard magazines. What followed was extraordinary. Gun shops sold out inventory within hours. Online retailers shipped tens of thousands of magazines into the state. Conservative estimates suggest over 1 million magazines entered California during that single week. And here's the critical detail politicians didn't want to acknowledge. Crime didn't surge. Violence didn't explode. Chaos didn't erupt. Freedom Week demonstrated something uncomfortable for gun control advocates. Ordinary citizens simply wanted access to equipment the rest of America already possessed. Nothing more, nothing less. The Supreme Court bombshell. But the real revolution came in 2022 with a Supreme Court case that completely rewrote how courts evaluate gun laws. New York State Rifle and Pistol Association versus Bruen didn't just rule on carrying permits, it obliterated the entire framework courts had used for decades. Before Bruen, courts applied balancing tests. States argued public safety interests justified restrictions, and judges usually agreed. After Bruen, those tests became irrelevant. The Supreme Court imposed a new standard: text, history, and tradition. If a gun law isn't rooted in the Second Amendment's original meaning or supported by historical precedent, it fails. No exceptions. No safety arguments. No balancing. When this new test gets applied honestly, magazine bans crumble. There's no historical precedent for limiting ammunition capacity. The founders wanted citizens armed with effective weapons, and the underlying principle was unmistakable. The people should not be outgunned by threats they might face. When the Ninth Circuit shocked the nation. With Bruen establishing the new standard, Duncan versus Bonta returned to the Ninth Circuit Court of Appeals. Plaintiffs argued California's ban couldn't survive under this framework, and then something remarkable happened. The Ninth Circuit, long considered the graveyard of gun rights cases, struck down the ban. They admitted that magazines in common use are constitutionally protected arms. They acknowledged that California's safety arguments didn't satisfy the new historical test. This wasn't just unexpected, it was seismic. If even the Ninth Circuit couldn't uphold California's magazine ban, similar laws across the country suddenly looked vulnerable. The precedent was set, and its implications rippled far beyond California's borders. Why capacity isn't about preference. Gun control advocates consistently frame magazine capacity as preference, claiming nobody needs more than 10 rounds. That framing is dangerously misleading. Consider the realities of defensive situations. Multiple attackers aren't rare. Home invasions, carjackings, and gang-related violence frequently involve multiple threats working together. 10 rounds disappear in seconds when facing coordinated attackers. Law enforcement doesn't accept these limits. Police officers routinely carry firearms with 15 to 17 rounds plus spare magazines. If 10 rounds were truly sufficient, why wouldn't departments hold their officers to the same standard? Stress destroys accuracy. Even well-trained shooters experience massive accuracy drops under life-threatening pressure. Real-world defensive accuracy rates can plummet below 25%. That means needing more rounds to stop threats, not fewer. The math becomes stark when examining realistic scenarios. 3 attackers, stress-reduced accuracy, darkness, chaos. 10 rounds become inadequate quickly, and reloading during a violent encounter isn't just difficult, it can be fatal. The Houston reality check. Theory meets reality in cases like the Houston home invasion. A homeowner, asleep in his residence, was jolted awake by 4 armed intruders violently breaking through his door. Imagine that moment. Darkness, confusion, adrenaline flooding the system. He grabbed his firearm, equipped with a standard capacity magazine, and fired to defend himself. He discharged more than 10 rounds during that encounter. Had California's restrictions applied, he would have been forced to reload while under attack. That pause, even 2 or 3 seconds, could have meant death. This wasn't an isolated incident. Defensive gun uses across the nation frequently involve multiple attackers, high-stress environments where accuracy plummets, and limited time windows where reloading isn't an option. Survivors consistently report the same experience afterward. They didn't count rounds. They fired until the threat stopped. That's why arbitrary capacity limits aren't just impractical, they're potentially lethal. Lawmakers debate numbers in comfortable hearing rooms, but people fighting for their lives don't care about statistics. They care about survival. Duncan versus Bonta recognizes a fundamental truth: the government shouldn't dictate how many chances someone gets to defend their life. California's counteroffensive. California didn't surrender after Duncan. When courts struck down the magazine ban, state lawmakers immediately launched a counterattack. Their strategy shifted. If outright bans couldn't survive judicial review, they'd bury gun owners under endless restrictions, declaring vast areas as sensitive places where carrying becomes banned, proposing mandatory liability insurance requirements before exercising constitutional rights, expanding training requirements, paperwork, and renewal fees that transform rights into privileges, passing emergency measures designed to confuse and delay gun owners even while lawsuits progress. This approach is often called death by 1,000 cuts. If one sweeping ban fails, perhaps countless smaller restrictions achieve the same result. The problem for California? Historical precedent doesn't support these tactics either. There's no tradition of banning carry across entire cities or demanding insurance to own firearms. These schemes are already facing legal challenges, and courts may strike them down using the same reasoning that killed the magazine ban. The national domino effect. Duncan's impact isn't confined to California. The ruling is creating a chain reaction across states with similar restrictions. Once one court strikes down a law using specific constitutional reasoning, other courts must grapple with that precedent. New York's SAFE Act, which includes a 10-round magazine limit, now faces lawsuits citing Duncan directly. New Jersey's 10-round cap is under renewed legal attack using Duncan's framework. Hawaii, falling within the Ninth Circuit's jurisdiction, sits directly in Duncan's shadow. California's ban falling could trigger Hawaii's collapse without new litigation. Illinois, which recently passed sweeping rifle and magazine restrictions, faces challenges leveraging Duncan's reasoning. This matters because momentum becomes self-reinforcing. When courts in multiple jurisdictions start striking down bans using the same constitutional analysis, it creates pressure even the Supreme Court cannot ignore. And when the High Court affirms that standard nationally, it becomes binding law everywhere. So here's the uncomfortable truth that's emerging from courtrooms across America. Magazine bans were never about safety. They were about control dressed up as common sense. For decades, politicians sold these restrictions using fear, claiming that limiting capacity would reduce violence. Courts just examined the historical and constitutional evidence and found none of it holds up. Duncan versus Bonta isn't just a California story, it's the first crack in a dam that's been holding back constitutional rights for generations, and that dam is starting to collapse. Right now, gun control advocates are scrambling to find new angles, new restrictions, new ways to achieve through complexity what they can no longer accomplish through direct bans. Meanwhile, cases are stacking up in courts across the nation, each one using Duncan as a battering ram against restrictions that would have seemed untouchable just 5 years ago. The Ninth Circuit's decision proves something crucial. When courts actually apply constitutional tests honestly, most modern gun control doesn't survive. That's not a political statement, it's a legal reality that's playing out in real time. But this is far from over. Every legal victory triggers political backlash. Every court ruling prompts new legislative attempts. The fight over the Second Amendment is entering a new phase, and Duncan versus Bonta is the opening salvo. States will keep trying new restrictions. Courts will keep evaluating them under Bruen's standard. And the fundamental question remains, do constitutional rights mean what they say, or only what politicians find convenient? The answer to that question will determine not just magazine capacity limits, but the future of the Second Amendment itself. Because if standard capacity magazines are protected arms, and the Ninth Circuit just said they are, then what other restrictions are built on the same shaky constitutional foundation? That question terrifies certain lawmakers, and it should, because the courts are finally asking it.